Okay, if you could just type in the chat box, that would be fantastic. Awesome. Okay, so for everybody that's on the webinar, to let you know, it will be recorded and it will be available via our website within 72 hours after the webinar taking place. So thank you all very much for taking time out of your lunchtime to listen to me talk about a year on from GDPR. It will be no more than half an hour, and there will be an opportunity for you to ask questions at the end. And I'll also be asking everybody that's on the webinar whether or not they would welcome a follow-up call with me. Obviously, you can say no, and there's absolutely no issue with that from me. So let's start. So my name's Kelly Peters. I am a co-founder of Data Basics. I've been working in the area of information governance for 20 years now and have been running Data Basics for 5 years with my business partner. And I am very passionate about data protection, and hopefully I'll convey that through the webinar today. So I wanted to start off with a very quick overview of what GDPR was to give us a starting point, and then we'll go on to the lessons learned. I will then talk to you about some things I believe that you should have considered in the last year, and then I'll give you the 10 commandments that we feel businesses could benefit from, and then there'll be your chance to ask us any questions. So the Act came into force on the 25th of May last year. It was new. It wasn't a revolution. It was an evolution of an existing regulation that had been in place in Europe for over 20 years. The thing to note is that in this country, both the GDPR and the Data Protection Act came into force on the same week. So the new regulation, as of a year ago, applied to everybody that was established in the EU. So everybody that's on this webinar, if your business is based within the European Union, this regulation applies to you. If you are an organisation that offers goods and services to EU residents, but you have no offices in Europe, the regulation applies to you. And if you monitor behaviour, so if you think about things like Fitbit, Garmin watches and whatnot, they again are monitoring behaviour of EU residents, therefore the regulation applies to them. A key question that has been asked over the last year is, does this regulation really apply to me? I'm only a small business, I don't process a lot of information, and the reality is that this regulation does apply. Not every aspect of it. For example, appointing a data protection officer. If you are a one-man band, the DPO requirement may be a little unnecessary for you. The regulation also applies to whether or not you as an organisation determine what you're collecting and how you're processing that, so that's a controller, or whether or not you outsource information to other organisations working on your behalf. Now, these may be organisations such as an external marketing agency. It may be a bookkeeper that you have working on your behalf. They also have responsibilities under the regulation. And the only time I'm really going to talk about the breach, because there was far too much attention, and I think that's a lesson that we can learn, far too much attention was focused on the possibility of a 20 million euro fine, or 4% of the annual turnover. Now, those types of breaches would only, in terms of that notification fee as such, charge would only come into force if you were significantly putting people at risk. So if you think about the likes of the British Airways breach that happened over the summer, where people's credit card information and potentially passport information was put at risk, that's when we talk about the larger fines. So what I wanted to touch on, because I think this has kind of been missed in the last year, and the ICO are now taking action on this, is that under the Data Protection Act of 2018, which, as I mentioned, came in at the same time as GDPR, there was a requirement for organisations to pay a data protection fee. Now, what has typically happened is a number of organisations felt that the data protection doesn't apply to them, therefore didn't realise that the fee applied to them. So my suggestion to you, if you are uncertain as to whether or not the regulation and the fee applies to you, is definitely take the self-assessment. The link is here on the webinar. It will take you no more than 5 minutes to complete. And at the end of it, you will be told whether or not you need to pay a fee. The fee for a very tier one like ourselves is no more than £40, which actually is not about a large sum of money. And it is this money that funds the Information Commissioner. She is not funded by the fines that are issued out to organisations. Now, the thing to note is that in the last year, and this has happened in March and April of 2019, is the Information Commissioner is now issuing enforcement notices on this particular action. So where she believes organisations should be registered with the Information Commissioner, they are receiving letters to say, please take action. If you don't take action, you are potentially liable for a fine, and the fines can be upward of £5,000. So for me, 5 minutes to determine whether or not you need to possibly pay £40 versus a letter that's telling you owe the Information Commissioner £5,000. I think it's well worth the 5 minutes of checking that. So why is data protection important? A lot of people feel that data protection is a tick box exercise, and it really isn't. It should be something that is considered in your everyday working environment, because it is about protecting individuals, whether these are your staff, whether they are your customers or clients, or if you deal with, in healthcare, patients. You have a responsibility to make sure that that information is not misused. You will hold information on individuals, even if it's just contact details. You'll have data. A lot of businesses and charities, and there may be both that are on this webinar, you will hold information on staff, future candidates, prospects, customers, experts, legal counsel if you work in the legal field. So it is about knowing what you're holding and why you're holding it. Now, great harm can come of misusing information. You can put individuals at risk of physical harm. You could put them at risk of financial harm if you don't understand what you're collecting, why you're collecting it, and for what purpose. And most importantly, you want to make sure it doesn't get into the wrong hands. So my view very much is that data protection should be seen as a privilege in terms of the access to data that you have, not an absolute right. So the first lesson is talking about breaches. Now, I was quite happy when I read the fact that there is an increase in reporting of breaches to the Information Commissioner. So a breach is whether or not you have accidentally lost information, you have inappropriate access to systems, you've been unfortunate in disclosing information to unauthorized individuals. Now, that may happen, and an increase in reporting is fabulous. However, what the Information Commissioner is reporting is that there is an over-reporting of breaches that don't need to be reported to her. So whilst you may need to report them internally, because they are not a high risk to individuals. So we're talking they are not a risk in terms of financial harm. There is a very low risk of emotional distress. There's potentially no risk of physical harm. These are breaches that do not need to be reported to the Information Commissioner. So it's great that people are reporting breaches, but they are in some instances reporting too many breaches. On average, businesses are waiting 3 weeks from the point of discovery to actually then reporting it to the Information Commissioner. Now, you have 72 hours from an ICO perspective to report a breach. So a lot of businesses are not taking into account what they should and shouldn't be reporting. Only 10% of breaches that were reported, people considered the actual impact. Now, if you're going to report something to the Information Commissioner, one of the first things you should be considering is what is the actual impact on the individuals that have been affected. So as I've already alluded to, we're talking about risks and freedoms to individuals, emotional, financial distress, and potentially physical harm. The most common type of breach that has happened is inappropriate disclosure. Now, most of those are via email. Now, all you have to do is look at the Information Commissioner's website and look at the number of organisations that have been issued a fine because they've sent an email with an Excel spreadsheet on it or an attachment that has gone to the wrong person, and that attachment happens to contain very personal and sensitive information. Some instances have been of children, have put children at risk. These are all breaches that can be prevented. So the lesson is, make sure that you're reporting them internally, your breaches. Know what the impact of the breach is, because that will determine whether or not you need to report it to the Information Commissioner, and possibly consider putting a 2-minute delay on your emails so that those inadvertent disclosures are prevented. And most interestingly, but not surprisingly, most businesses are likely to be hacked on a Friday. Now, my question to you would be, if you were told that your databases were being hacked on a Friday, what would you do? I would hope that you would look at isolating the issue and taking things offline. Some people may just wait till Monday. Now, if we consider that it's a bank holiday weekend today, you will have missed the 72 hours if the breach is actually affecting rights and freedoms of individuals. So what I would suggest, whilst they can be bad news, you can learn a lot from data breaches. So in terms of your organisations, what I would ask you to consider is, how prepared are you for a potential data breach? And would you know what to do? And whether it's you, does all your staff that you work with, would they know what to do if there was a breach? Now, many people say to me, we've never had a breach, Kelly. Well, that's great. You are likely to have one. It's statistically possible that you will have one. So learn from near misses from other organisations that have had breaches. Go onto the Information Commissioner's website, look at the type of breaches that are happening, and ask your teams, if this was to happen to us, what would we do? The next one, and I'm sure most of you on this call are very familiar with this, is that this time last year, you were being bombarded in your email boxes with asking you to consent or reconsent for marketing material, and not just marketing, but predominantly marketing. Now, what happened is that those emails went out, and then the following week, you were still getting messages from people because they hadn't taken you off the list. They had changed their mind about the lawful basis for processing the marketing data. So they went from an opt-in to an opt-out. Now, from a data protection perspective, that's a no-no. Your responsibility as an organisation is to determine the valid lawful basis that you're going to be using for processing personal data. Now, once you've determined what that purpose is and what that lawful basis is, unless the purpose change, you're unlikely to change your lawful basis. Now, no one basis is better than the other, so it's your responsibility to determine the most appropriate basis of processing that data. If you have lost 80 to 90% of your marketing database, you'll have to start afresh in terms of identifying new contacts and new prospects to market to. If you haven't had a response, you can't, and your basis was consent, you can't contact them again. Now, what I would also say is consent isn't just about marketing. There are a lot of other processing that's happened that is using consent. Google was fined 50 million euros under GDPR because they were not transparent about how they were getting consent from people that were accessing their site. So if you're going to use consent, make sure it is the right lawful basis for you, and make sure it's a positive opt-in. Now, if you have decided that consent's not the right basis for you and you genuinely want to use legitimate interest, it should not be seen as your get out of jail for free card, which to be fair, in my opinion, a lot of organisations made the decision that they will have a legitimate interest. Now, if you have a legitimate interest, it is your responsibility as an organisation to undertake a legitimate interest assessment. Now, in the last year, the companies that we've gone into and we've seen and we've asked them where their assessments are for legitimate interest, they cannot show them to me. So my answer or my question to you is, look at what you're processing. If you're processing it on a legitimate interest basis, you need to do the balancing test. You need to know what's the purpose. Is it absolutely necessary? Is it the most appropriate lawful basis for you to be using? And is it balanced? And the balance has got to be from an individual's perspective, and your overriding requirement cannot override the individual. So is there a balance? Now, fraudulent detection of credit card fraud, for example, is a legitimate interest. I'm a credit card card holder. I am happy for my credit card company to check for any fraudulent activity and to notify me if that happens. That's their legitimate interest. And for me as the individual, I am happy for them to conduct that assessment and to let me know, because ultimately I benefit from not being affected by fraudulent activity. So if you are using legitimate interest, make sure you've done the legitimate interest assessment. A lot was talked about individual rights, and there are more rights and stronger rights under the GDPR in the last year. What we need to be thinking about is how all these rights apply to you. And one that I feel is misunderstood or not really appreciated as much as it should be is the right to be informed. A lot of organisations are focused on the right to access, which is absolutely perfect. But the right to be informed is a requirement on you as an organisation to advise individuals how you got their information, how you're using that information. In particular, if you are obtaining information about individuals from third-party sources. Now, I have seen people take information from LinkedIn, pull it into their CRM systems and start marketing to people. What they haven't done is advised individuals how they got their information, why it would be relevant for you to be contacting them, and given them the option to opt out. And they certainly haven't contacted these individuals in a 30-day period. So if you're buying a data list, you want the absolute assurance about where that data has come from and that people have opted in and they know it's going to be shared with organisations such as yourself. If you are taking information which you believe is in the public domain from people's websites and you are pulling it into your databases or your Excel spreadsheets, you have a responsibility to contact those individuals and let them know that you've got their information, what you're going to be using it for and how you're going to be using it, and then give them the option to opt out. And if they opt out, you cannot contact them again. Why is this so important? Because a lot of focus was on all data breaches as being a fine, organisations being fined, but a company under the Polish authority was given an enforcement notice for 220,000 euros because they simply hadn't contacted the individuals on their system and advised them about what their information they were holding, why they were holding it, and how they were being used. So the right to be informed is absolutely critical. So my call to action to you is where you've obtained data from a third-party source, double check that you've informed those individuals. If you haven't, you are not meeting your obligations under the regulation. The next lesson is that in the past year, there have been a number of cases that have hit the press. If you take, for example, Facebook have been in the press quite a lot. There was a big outrage about how they were sharing information with third-party organisations where application developers were attaching information to Facebook and pulling data through their system from Facebook. Now, in the ideal world, and certainly from a GDPR perspective, they should have done a data protection impact assessment. They should have determined the risks that were associated with processing that information. They should have considered the controls that were put in place, and did they have the appropriate security in place to handle any potential breaches in data protection. Now, to bring that down to a much more local, smaller business perspective, is if in the past year, as part of Making Tax Digital, you have moved to a new Making Tax Digital system, and they are the likes of Xero, QuickBooks, for example, or Sage, have you done a risk assessment on that? You are processing a lot of people's information, potentially information about it will be about their bank details. What else are you collecting in that system? Have you considered the risks? Have you considered undertaking a data protection impact assessment? Are you linking your Making Tax Digital system to your CRM system? So when you bill a client, you're billing them through the CRM because it's linking to your MDT system. If so, have you considered the risks? So my lesson learned here is really new systems are great in terms of increasing our ability to be more efficient as businesses. However, we cannot forget our responsibilities under the Data Protection Act to make sure that we have appropriately considered all of the risks, in particular, if we are dealing with high risk information and we are, again, thinking about sensitive information that could lead to fraudulent activity. So please undertake a DPI. They shouldn't be a lot of time. Can I just check that everyone's okay to hear me? Okay, I understand that there are a few people having a few technical issues. I just want to make sure that I'm coming through okay to everybody. Okay. Oh, I've skipped a slide. So what do you have to do from a DPIA perspective? So if you have to conduct a data protection impact assessment, you need to be considering the scope and the purposes of your processing. You need to make sure that justifying why is it necessary? Is it compliant? You have to consider the risks, and like we said here in the example, what are the rights? What is the impact on individuals' rights and freedoms? Could you introduce this new system of data collection put people at a disadvantage? Could you cause, if the data was to be inappropriately secured or given free access to everybody, could it cause physical and mental harm? What are the real likelihoods of the risks that are happening and the level of severity? So if your likelihood is low and the impact is low, then you don't need to invest heavily in massive security measures. However, I would say if the likelihood of you being hacked and it will have a massive impact on individuals, you'd want to make sure that you have appropriate security measures in place to reduce that potential issue. And most importantly, you want to be able to mitigate those risks. So the last lesson, but for me it's the most important lesson, is about demonstrating accountability. Now, under the GDPR, accountability is a natural principle. Now, the Information Commissioner, Elizabeth Denham, states that accountability shouldn't just sit with a data protection manager or data protection lead, or if you've appointed a data protection officer, it should pervade the entire organization. So everybody should understand what the role they play in data protection and how they can help the organization reduce the risk of any breaches or inappropriate access or use of data. So to be able to do that, one of the key tenets for me is training. Now, if you have a breach, one of the questions the Information Commissioner is going to ask you is, when did you train your staff? How often do you train your staff? So the question for you to be considering is, how often have you provided data protection training to mitigate legal, financial, and reputational risks? Do you run any kind of data protection drill? So I know organisations where they will test their team members to see if they will open a phishing scam. Do you do run test scenarios. Well, here's a fake breach, but let's test the team to see how we handle that type of example. What happens if your receptionist gets a subject access request but doesn't know how to handle that? So it shouldn't be one person, unless there is just you in the business. Then it's your responsibility to be aware of what your requirements and responsibilities are under the regulation. So please train your staff and become accountable, but also think about elements that the Information Commissioner has recommended that you put into practice, which helps you demonstrate your accountability from a data protection perspective. So if you're going to do training, you really should have a policy on data protection. Now, it does not have to be 100 pages. It has to be practical. It has to be something that your staff know how to follow. Do you know where all your data is and why you're processing it? So where we talked about earlier, whether or not you're using consent or legitimate interest, do you know that, and have you mapped your data? We haven't covered it, but I know it's an issue. A lot of organisations do still today do not have robust contracts in place with their supply chain. And in particular, by highlighting what the data protection requirements are. Have you put appropriate security measures in place? Now, this may be as simple as putting in that little 2-minute delay in your email so you're preventing inappropriate disclosure of attachments. It may be that you have told all of your staff that are working remotely to, if they're going to access work information, to access it via a secure connection and not through public Wi-Fi. So what are the appropriate security measures you've put in place? Are you recording breaches? And where necessary, reporting them to the Information Commissioner? Have you determined whether or not you need to appoint a data protection officer? And if you've signed up, so if you are a professional body that you have to adhere to professional standards, do they tell you what else you need to demonstrate to be compliant? So the anti-money laundering requirement stipulates that if you're doing the anti-money laundering checks, your staff that are running those checks have to understand data protection. So it's a totally different regulation, but it talks about data protection. So really make sure that you know what your codes of conduct are and that all that should be meeting those requirements are. So this might be a little small, but I can email this out to everybody in a PDF format. So here, and these may be really simple, but to me they are pretty fundamental as data protection commandments. Now, my very first one is don't reuse passwords. Passwords are routinely hacked. They are typically the number one password globally is 123456. I kid you not. So please consider having different passwords with a little bit of complexity in them, or even consider a password manager. Do treat people's other data as you would want your information to be treated. Make sure that you don't leave unattended PCs, laptops, mobile devices. I have spent too many times on trains where I've seen people get up, go to the bathroom or in a cafe, and they've left their laptop open for the entire world to see whilst they either go to the bathroom or get a refresh of coffee. You can't keep data forever. As much as we all like to hoard information because it gives us that reassurance, you do need to make sure that you're only keeping information for as long as is necessary. Remember, it's not a tick box exercise. Data protection should be something that is covered by a data protection policy as well as through training. Mistakes happen, so record them. Make sure you understand what the mistakes are and that you learn from them as an organisation. If you're using cloud-based systems, such as Dropbox, for example, ask the question where the data is. Simply don't say it's in the cloud, because as a controller, you've not done enough due diligence to really reassure anybody that you know where your data is being stored. Remember that staff and employees and customers have the right to access the information. And if they put in a request, you have to respond to that within 30 days. We've talked about contracts very briefly in the last slide, but make sure you've got appropriate contracts in place. And that will become even more important if and when we leave Brexit and whether or not we leave in a hard Brexit or not. And make sure, please, I know it can be quite a drain on systems. You may not need to update your system on a Monday morning because it may take hours depending on how many updates you have to do. But please run your system updates. If you're using, for example, WhatsApp had a potential massive issue last week. And the thing that they issued out to everybody was please update all your software because they've put a patch in place. So be responsible, make sure your system and software is updated. So I'm going to open up the floor now to you guys and say, what questions do you have? And we've already got one, which is great. So please type in whilst I answer the first question. So the question is, are photos and videos classed as data? And this is a really good question. The reason it's a good question is photos and video of individuals is classed as personal data. If you have an image of an event, then data protection doesn't apply because you are recording an event. And to make it a bit real, can you imagine asking everybody at a football game to ask for consent because their photo or their image may go onto the big screen because it's being videoed? So if you're going to have photos of individuals, you do need to get them to agree for their information to be included within the brochure, on the website in terms of their photo, for example. If you are going to do events, I would always recommend that you tell people that you'll have a roaming photographer, and for anybody that doesn't want their photo to be taken, to maybe mark them with a simple sticker that says, as a little red sticker, for example, so that the photographer knows not to capture them into the photos. So the next question is, you're at an event and people are scanning. So you've gone to an event, a company is scanning your badge, and they have told you that they are GDPR compliant. Now the question for that is that, well, no. So they can't just scan your badge. If you're at an event and you're attending, what they should be doing is they should, in my personal opinion, they should be asking you whether or not you want to follow up from them. Just because you've stopped at their stand, you may be stopping at their stand to get a sweet or a free pen, for example. So you shouldn't automatically be scanning someone's details into the system on an event. I would explain to them, if they do want to hear from you, you would then scan their details. I would also want reassurance about how they're going to use that information if they're only going to be using it for marketing purposes. So the next question we have, so the question is a really good question, is with regards to the 72-hour deadline of reporting a breach, the understanding is that it's 72 hours from the point of being aware, or is it the case that it's from the point of the breach? Now, for me, it's the minute you've become aware of the breach, because you may not know. So some organisations have had their websites hacked, and they were hacked months ago, and they were simply not aware that they were hacked. So the minute you become aware, as far as I'm concerned, you should be taking action. If the time that you've become aware is the same time that the breach has happened, brilliant. It means that you have really robust systems in place. But definitely, from the minute you become aware that you have been breached, take action. Whether or not you have to report to the Information Commissioner, you want to be in control of that breach. Another question we've got is about automated decision making. Now, automated decision making very much is, for example, if you're applying for a loan, for example, you do it all online, you never talk to anybody. The algorithms behind the scene make a decision as to whether or not you are suitable for a loan or a credit card. That's automated decision making. Now, if you don't have or don't use automated decision making, I would simply put on your privacy policy and your data protection documents that you don't use automated decision making processes. And I think that's an easy, hopefully relatively easy for you to do. Okay, so another question that we have is, can an individual waive their legal rights under DPA and GDPR? Now, there has been a lot of debate about this recently as to whether or not you as an individual, as part of your settlement agreement, you accept that you will not put in a subject access request following that settlement agreement to the company that has settled with you. And I think there is a split view. Some feel that, you know, as an individual, you've made the decision to not take any further action in terms of the subject access request, and the law doesn't stop that from happening. Then there's the other 50% of coming at it from a much more ethical perspective to say that actually, even though you've settled, the individual still has the right to access their information. So for me, I think it's really whether or not any of these cases actually go further than settlement to see how this is handled. So it's real 50-50 at the moment. I know it's not an ideal answer, but that's what I'm seeing at the moment. Do we have any other questions? So whilst I'm waiting to see if there are any more that pop up, I'm just going to do a quick little spiel about us, and then I can come back and answer some of the questions. So 60 seconds about data basics. For those that don't know, we're very much about, we're people. We want to raise awareness, help you engage your staff. If you want training, whether it be bespoke or online, we can provide you with that support. If you don't know what data you have, where you have it, and need some help with mapping, we will be able to help you. And if you want help writing information systems and policies and processes, again, that's something we can do. So if you're uncertain about how to handle data protection and you want a little bit of advice and guidance, give us send us an email. I'm sure we can help you. I'll put our contact details on here, so they're up there. So the question that has just come up now is, can you use public information about organisations? So if all you're using is the organisation name and you want to send them letters, and it's maybe you're writing to the director, so it's dear director at organisation XYZ, there is no personal data whatsoever, then data protection doesn't apply, because at that point in time, you are not collecting or processing any personal data. If from that website you happen to have a name of who the director is, and you take that name off the website and you want to use it for your purposes, it's your responsibility to inform the director how you got their contact details and how you intend to use that information, and give them the option to opt out. Good question. To be fair, the question is there a simple data protection impact assessment template? The one from the ICO website, it seems a little complex. The one that I saw was about 5 pages long, and it's probably one of the simpler ones that I've seen. But essentially, the questions that I loaded up earlier on in terms of what you should be considering are what you should take into consideration for a DPIA. So what's the processing, what's the purpose, what are the risks, what are the mitigations in place, what are the flows of data, and make sure that whatever is the outcome of that is built into your systems and your processes. You can absolutely get a copy of the webinar. The webinar will be available early next week after the bank holiday, so it will be on our website. But for everybody that has attended, you will get the link to that. What I would say is, we've still got 1 or 2 questions. So it's really great to know that this has been a useful conversation. So let the question come up. What I would simply ask you now, and it's more for my purposes than for anything else, what I would suggest is, if for anybody that does want a follow-up call from me, and please, let me reassure you that if you don't want one, I will not hassle you. I will simply send you the webinar link. But if you do think it's worthwhile having a 15-minute, no obligation call, if you could type yes in the chat box, that'd be fantastic. So the question that we have is, what sort of contracts do you need? And can you just have terms and conditions? You can have terms and conditions as long as they have a data protection clause in them, to be perfectly honest. And it entirely depends on what the contracts are. So you've got employment contracts, you'll have third-party supplier contracts. If you're buying something online, you may just want terms and conditions. But whatever option you choose, you should have data protection clauses in them, and it very much should explain what you're using the data for, what you will do if anything happens to the information, how you'll report any breaches, for example. But I can happily, as part of the email I send out, I can send you just links to some standard contract clauses that the Information Commissioner believes will be relevant. If you do want contract help, I'm not your person. I'm not legal in that respect, but I can certainly point you in the right direction. Okay, so we've got 2 more minutes. Are there any more questions? Okay, well, what I'd like to do is just say thank you very much. I know it's the Friday before the bank holiday. I know it's a lunchtime. I really appreciate the fact that you've taken your time today to listen to me talk about data protection. I'll send you the webinar. I'll send you details of our next webinar next month, which will be about all the finance and accounting perspective. But thank you. I very much appreciate you taking part and asking me so many cool questions. Brilliant.